Merci, Monsieur le Président, et merci à la membre du Sous-comité. C'est un grand plaisir d'être ici et merci pour l'opportunité de vous joindre aujourd'hui. Exactly 7 years ago today, my friend Masih Alinejad testified before this very committee. As an Iranian journalist and one of the leaders of the women's rights movement, she warned of the dangers posed by the Islamic Republic of Iran. Not long after returning to her home in Brooklyn, Iran tried to kidnap her. The regime hired an operative to abduct and return her to Iran to face likely execution. What is exceptional about Masih's story is not that Iran ordered her kidnapping, it is that she survived. Most others have not. We live in what scholars have called the golden age of transnational repression. Since 2014, Freedom House has documented close to 1,400 incidents across 107 countries, carried out by 54 governments against their citizens in exile. These numbers continue to rise every year. Even where direct perpetrators are caught and prosecuted, as Masih's would-be kidnappers were, the statistics still do not go down, because transnational repression is, by definition, a leadership crime. It is not the spontaneous misconduct of rogue agents. It is the deliberate exercise of state power directed from the top against individuals whose only transgression was to exercise their right to freedom of expression or opinion from the supposed safety of exile. The operative who attempted to kidnap Masih did not act alone. Behind him was a chain of command, a budget, an intelligence apparatus, and at the top of that chain, a senior official who gave the order. It is that person, the official who authorized the operation, who has never been held to account. And that gap is the topic of my testimony today. The international community has studied transnational repression extensively, condemned it at the highest levels, and built policy frameworks to counter it. The G7, for example, under Canada's presidency, has declared that TNR undermines national security, state sovereignty, and the safety of human rights. 45 states signed a joint statement at the UN Human Rights Council in 2024 calling for coordinated action against it. This committee has heard powerful testimony about its human cost. What the international community has not done is hold anyone criminally responsible for ordering it at the highest levels. The focus has been on detection, disruption, and diplomatic pressure. Nobody is asking who bears criminal responsibility for directing transnational repression as a matter of state policy. The current responses, therefore, have very real limits. Criminal prosecutions of operatives matter, but they can cover only those who carry out these crimes, not those who command them from abroad. And targeted sanctions, which have been an important tool that we've been using and should be used even further, still only levy costs without generating criminal accountability. They can be lifted under diplomatic pressure, for example. So a senior foreign official who calculates that the worst case outcome is a travel restriction has been given insufficient reason to stop. The result is a landscape of responses that generate visibility without accountability and leave the command architecture of TNR entirely intact. The architects of these campaigns have drawn a clear conclusion. The international community will document these crimes, prosecute the low-level operatives, maybe sanction some associates, but it will do nothing to threaten their personal liberty. Until that calculation shifts, TNR will continue being ordered by the commanders and senior officials of foreign regimes. International criminal law was built precisely to protect individuals from the criminal exercise of state power and to ensure that those at the highest levels who ordered these atrocities cannot hide behind their office or mandate. The dissident hunted across borders by the state she fled is exactly the kind of victim this framework was designed to protect, because she is someone for whom no other remedy exists. I'm seeking to underscore in my testimony today that the foundation to respond exists through the International Criminal Court and has simply never been used. Under Article 12.2a of the Rome Statute, the founding treaty of the ICC, the court has jurisdiction where an alleged crime was committed on the territory of a state party. TNR operations produce their effects where the victim is located, on the soil of the host state. If that host state is a Rome Statute party member, the ICC has jurisdiction over those crimes. Even if the primary perpetrating states are not Rome Statute members, and most of them are not, like Iran, China, and Russia, their victims are almost always located in jurisdictions that are members of the court, including Canada. I will note that Canada led a statement of the G7 condemning Iran regime transnational oppression and a further statement of 14 countries condemning, quote, attempts of Iranian intelligence services to kill, kidnap, and harass people in Europe and North America in clear violation of our sovereignty. These services are increasingly collaborating with international criminal organizations to target journalists, dissidents, Jewish citizens, and current and former officials in Europe and North America, end quote. As you know, the founder of our center, Professor Erwin Kotler, a former Minister of Justice and Attorney General of Canada, was one of these Jewish citizens and former officials targeted for assassination. So the widespread and systematic nature of this transnational repression targeting civilians as a matter of Iran state policy meets the exact legal definition of a crime against humanity. So to conclude, I would therefore urge the subcommittee to consider calling on the government of Canada to refer Iran's transnational repression to the International Criminal Court. Canada can even lead our allies that are members of the ICC, like the other 5 members of the G7 who are members of the court, the other 12 signatories of the joint statement on Iranian transnational repression who are members of the court, to jointly refer the case to the ICC and even allocate resources for the court to prioritize it. This would set a major global precedent that would resonate far beyond Iranian transnational repression to combat global TNR. Mr. Chair, too many Canadians continue to adjust their routines, triple check their locks, and look over their shoulders because the foreign architects of this transnational repression know they are protected by a culture of impunity. This subcommittee can help change that. Merci beaucoup.
Merci.
Merci, Monsieur le Président. Monsieur Silva, j'aimerais peut-être qu'on aborde le dossier de Monsieur Jimmy Lai qui reste emprisonné présentement à Hong Kong suite à la fameuse loi sur la sécurité nationale. Bref, et c'est quand même un citoyen britannique. Il y a quand même un lien à faire en termes de répression transnationale. Il y a aussi quelque chose de particulier ici au Parlement, c'est-à-dire qu'on a un député qui a été élu sous la bannière conservatrice, M. Michael Ma, qui a traversé chez les libéraux, mais entre-temps, il avait été élu. D'ailleurs, c'est la meilleure chose qu'il soit arrivé au caucus conservateur dernièrement, que M. Ma ait traversé de l'autre côté. Mais c'est une blague entre nous. Ceci dit, M. Ma a été élu comme étant le président du groupe d'amitié Canada-Hong Kong lorsqu'il était conservateur. Il s'est retrouvé à traverser l'allée pour rejoindre les libéraux et a fait des déclarations très surprenantes et malheureuses en questionnant à savoir s'il y avait du travail forcé en Chine, alors que les études, je veux dire, il y a des milliers d'études qui le démontrent. Et pendant ce temps-là, tout ça est relié à M. Jimmy Lai, comment, dans un Parlement canadien, le président du groupe d'amitié Canada-Hong Kong puisse être celui qui questionne le travail forcé en Chine. Et comment se fait-il, d'ailleurs, que cette personne-là soit restée silencieuse face à la tragédie qui affecte M. Lai et sa famille?
Merci pour cette question. Je vais répondre en anglais pour être plus clair. You know, I firstly want to thank my colleague Luke DePulford for raising how emblematic Jimmy Lai's trial is when it comes to transnational repression. And I want to expand on that to your question, MP Brunel de Sepp, about, you know, the need for Canada's parliament and parliamentarians to be more focused and engaged on the case. This really cuts to core Canadian interests. The national security law under which he is being prosecuted is draconian and extraterritorial. What Hong Kong and its masters in Beijing feel that they can get away with in doing to Jimmy Lai as the most prominent person being prosecuted under this law will thereafter be applied to Canadians on Canadian soil. When Parliament and government was not outspoken enough on Jimmy Lai's case earlier, we saw that happen. Thereafter, you had the same law being used to pursue bounties against Canadian citizens on Canadian soil. And more than that, as a middle power, engagement with the UN, with multilateral institutions, are a core part of our foreign policy and sovereignty. Even engaging with the United Nations can be criminalized under the national security law. When a complaint was filed against the Chinese embassy and the UN asked them, can, you know, anyone talking to us really be prosecuted under the NSL? Under paragraph 56 of China's response, it's so brazen that they put it in writing. Paragraph 56 says, yes, it can be the case. So a Canadian in Canada engaging with the UN, even on Mr. Lai's case, can end up with a bounty and facing trial. And we risk greater and greater incursions on our own sovereignty via this law if we do not speak out more concertedly and concretely on Mr. Lai's case. And I also want to commend you and the members of this committee that have held hearings on this case, which help sustain him and his family and shine a spotlight on these issues, and the efforts that you all spearheaded to grant him honorary citizenship. again, it's a testament, to these values and helps to push back against these efforts on transnational repression. So, and I would encourage any member who has not done so, or even may engage adversely, as you suggested, to reconsider what the implications of that might be for Canada's sovereignty and Canadian citizens.